Tobago.
Oh, Mr. Clayton, sorry you preempted that, but no doubt you found that summary, as we all did, extremely edifying and interesting.
Thank you very much, my lords. As your lordship and my lady will know, I appear together with Mr. Ram Logan and Mr. Richards, my learned friend Mr. Rowe, for the respondents. My lords will know that this is a damages assessment following the board's decision about the failure to award a license to the appellants, and that failure was held by the board to be discriminatory. When the case came to a damages assessment before Mr. Justice Budu Singh, he found that the appellants would have commenced operations on the 1st of August 2002 and were in fact awarded a license on the 22nd of September 2006. He saw one of his roles as ascertaining the profit for that period, and he assessed the likely profitability. He heard evidence from only two witnesses called by the appellant, Mr. Sat Maharaj, who was the chairman, and Mr. Devant Maharaj, who was the chief executive officer. The judge accepted them as truthful witnesses and made a small discount in terms of their evidence of reducing, I'm saying the costs were 10% more than they indicated. There was no evidence adduced by the defendant, and we have three very short submissions for my lords this morning.
We would have expected them to be very succinct, Mr.
Yes, well, I shan't be that long. The first is we contend there's been an error in the approach the learned judge took towards the absence of a competitive environment. We say that there's a second error in relation to his approach to the increase from year one to year two, and we have a very short submission on costs. Dealing with the first submission, first the error in the approach to the competitive...
Do you propose to address us on the question whether this is a case where concurrent findings of fact should be overruled?
No, I'm going to... I don't propose to suggest that, but the submission I'm going to make is on the basis of taking the judge's whole findings as they are and indicating why we say an error of law has arisen. The second submission is more fact-oriented.
Well, can you identify the error of law?
Yes, I was just about to. What I wanted to do, if I may, is invite you to look at the judgment and particularly turn to page 1079 of the electronic bundle. I'm sorry, the numbering, rather irritatingly, is the tiny numbering at the very bottom, which for those of us who it's volume 3, I should have said that, sorry.
So it's the numbering at the bottom, is that right?
Yes, at the very bottom.
Electronic page 1079. Yeah.
1079.
Yeah, it appears at the top as well. But anyway.
So it does, sorry. Yeah. It's so small I can't.
That's all right, don't worry. Well, now, we're waiting with eagerness to hear what the error of law is.
Certainly. If your lordships have the page which says compensation,
yep.
Just picking it up from about the first hole punch, well, what I have, middle of the paragraph, had the appellants been granted license earlier, they would have been operating sometime before. Had that happened, they would have entered into a market at a time when there were fewer radio stations operating. Also, none of them would have had the emphasis on the Hindu market as this station, that is, with designated Hindu religious programming. During that time, other stations came onto the market. At the time of the appellant's entry in 2007, it can therefore reasonably be supposed that they would have had a harder time to gain a market share. There would have been greater competition than before, and they would have lost the time over the previous years to build their listenership and advertising customers. Of course, they could have faltered in the way. I'm inclined to think that's an unlikely possibility. Now, if one then runs through the judgment, turning to the page, and I'll summarize this really pretty quickly, the judge holds the middle paragraph of the following page.
Which page?
Page 1080. on the balance of probabilities, having taken account of the speculative nature of the income and expenditure projections represent, I'm nevertheless of the view that the appellants would have made a fair profit, and he takes the view they would have improved their profitability over time, makes some points about the witnesses, and then if I could ask you to turn to page 1082. What he's done in the interim is refer to the growth figures, which I don't trouble you with. And then goes on to say at 1082, huge jump from the first year operation to the second, thereafter a steady increase. He doesn't think there's sufficient explanation for the applicants for the significant increase in the profitability projection. Given the estimates of profitability, he thinks more likely that profitability would not be as high. The onus was on the appellant to explain why the revenue figure from advertising would have increased to such an extent and set out the methodology to arrive at that figure. Even where no contradictory evidence is advanced, an applicant has a responsibility to show why their figures, especially where they seem to be unusually accepted. And then he says the estimated, unable to act on the unestimated probability of 160%. He then deals with the expenses matters. He then, turning to page 1083, says, I'm constrained in considering making a compensatory award toward more conservative figures. Then he ventures to suggest that given the position of the applicants as a reasonable projection, 20% profitability in the first year, and after that an increase of 10% in the next following years. And then he says they're conservative projections, the end of the next paragraph. Applicants bear the burden of proof. In the absence of detailed explanations, he makes reasonable conclusions based on his findings that a company very likely to succeed in its business operation to improve with time. It may well or would have been better, but since profits are affected by many factors and is speculative, a court must be restrained in its assessment. Now, I don't quarrel either with the approach of the judge in general, given it's the case we have before us, but I do make this point, which is really the passage I began with. It was clear that the judge regarded as an important part of this case that the competitive environment was different before 2006. And that was at page 1079. And the plain fact is that having identified that as one of the central issues in the case, one would have expected it to be specifically addressed in the reasons. I mean, there could have been any number of things that could be said.
Well, it was present to his mind quite clearly, wasn't it?
Well,
because he doesn't pick the theme up again when he's explaining how he calculated damages, doesn't mean to say that it's been left out of account.
Well, with respect, my lord, our submission comes to this about this part of the case. Well, this is a different point from the first to second year jump. But our submission is that where a judge is dealing with a central issue in the case, one would expect the reasons in the judgment to expressly reflect it. And in saying that, I'm not stating new law, but it's worth reminding oneself, and we put it in the bundle in cases of any interest, the Emery and, the English and Emery Reynolds case, which is the English reasons case. But the bottom line really comes to this, is that it was an important factor in the case. And there were three options the judge could have said. He could have said, I don't accept there was a difference in the competitive environment. He could have said there was a difference, or he could have said there was a difference, but it makes no difference to my approach. It doesn't do any of those things.
But your client's case was that there was a difference of competitive environment.
Yes.
Yes. And they put forward their estimates in the knowledge of that.
They did. But
so what were you asking him to do, to increase the gross revenue above your own estimates?
No, the debate, with respect, my lord, was about the rate of increase. I mean, in fact...
No, we're not on the rate of increase yet. You're still on point one, which is...
Well, I am, I suppose, but the point I'm trying to make is this, is that it was clear from the way the appellants put their case at first instance that the competitive environment point was of some importance. And it's a short, but in our submission, not unimportant point, to say that it's never addressed, and one would expect it properly to be addressed.
But that's not a question of, that's not a proposition of law. It's really a suggestion that the appeal should be allowed because the judge misconducted the proceedings or failed to address himself to the relevant issues.
Well, with respect,
which
my
is a
Lord, can I
different
take
point.
you to tab 19, because that isn't the position about the authorities bundle, tab 19. It's the judgment of Lord Phillips, then the Master of the Rolls. And again, I can take it pretty quickly. I'm not sure, it's a case about it's expert evidence. Sorry, is it 2089 of the electronic bundle? I'm sorry.
Yes.
It deals, no, there's no relevance to us about human
My,
rights and common law.
My bundle stops at 2088. Was this separate?
Oh dear.
I don't have a tab 19.
There's a separate...
Oh, right, okay.
So sorry,
I'm there now.
thank you very much. I'll just take you to the second page of the judgment, the first holding, and then to the reasons given by Lord Phillips. A judicial decision which affects substantive rights of the party should be reasoned, although some judicial decisions, interlocutory case management decisions, do not require reasons. While the judge is not obliged to deal with every argument or to identify or explain every factor which is weighed with him, the issues, the resolution of which were vital to his conclusion, should be identified, and the manner in which he resolved them briefly but clearly explained. So his judgment enables the parties in any appellate court readily to analyze the reasons essential to his decision. And then if we can turn through, please, to page 2097 of the electronic bundle. It's an issue about the adequacy of reasons, as my lords would readily appreciate. My lords and my lady, forgive me, readily appreciate. As to the adequacy of reasons, it's been said many times, this depends on the nature of the case. Flannery and then some older cases, but then a reference to...
Sorry, which paragraph are you reading from?
I'm so
Right,
sorry.
17,
17,
right, and
so
there, right.
Lord Justice Griffiths, when dealing with an application in chambers to strike out for want of prosecution, a judge should give his reasons in sufficient detail to show the Court of Appeal the principles on which he's acted and the reasons which led to his decisions. They need not be elaborate. I cannot stress too strongly that there's no duty on the judge in giving his reasons to deal with every argument presented by counsel in support of his case. It's sufficient if what he says shows the parties, and if need be, the Court of Appeal, the basis upon which he's acted. Then at paragraph...
Well, is it not sufficiently clear from the first instance judge, in this case, his judgment, that the basis on which he has acted is evident, is it not?
Well, with respect, we submit, no, it's not at all. What one would expect to see... Sorry, can I just complete what because I wanted to...
Just so that I know what point this case goes to that you...
Yes.
Are you submitting that the principle in this case means that the judge has got to, so to speak, attach a value to each element, a financial value to each element of the argument, i.e., to take account of the lesser degree of competition, I add so much to the price, and so on?
Well, I'm not going so far as to say...
Because there are reasons here. What you say is they don't specifically address one strand of the argument.
Precisely so. That's precisely, with respect, I accept that. And I'm certainly not suggesting that in relation to every element of the exercise that reasons have to be given. They have to be adequate. But what I am saying is that when it's the central strut of the case about profitability, that the market conditions were different, and there's all sorts of evidence on this, and it's challenged without success by the respondents at first instance. It comes squarely within paragraph 19. Can I just take you to that of the judgment? It follows that if the appellate process is to work satisfactorily, the judgment must enable the appellate court to understand why the judge reached his decision. This does not mean that every factor which weighed with the judge in his appraisal of the evidence has to be identified and explored, but the issues, the resolution of which were vital to the judge's conclusion, should be identified, and the manner in which he resolved them explained. It's not possible to give a template, doesn't necessarily involve a lengthy judgment. It does require the judge to identify and record matters which are critical to his decision. If the critical issue is one of fact, it may be to say one witness is preferred to another because one has a better recollection. That's not the case here. I should say that's not, let's make that observation. But our submission is no less and no more than simply this, is that in order to justify a claim that the profitability during the early years had to be higher, a substantial amount of evidence, in the context of this case, was adduced to say that there was a difference in the competitive market. And that's accepted by the judge. That was why I took you to the passage to begin with. And in our submission, it's unsatisfactory. It's a matter for your lordships as to how unsatisfactory it is, I of course accept. But it is unsatisfactory that there is no express consideration in the judgment of it. There's simply...
One of the points that Lord Phillips makes in paragraph 25 is that if the problem is that he hasn't spelled out his reasons, then in our system where an application is made for leave, it gives them a chance to try and expand them. Now, this judgment was given in 2009. Did anyone say to the judge, well, you haven't dealt with this?
No. It
wasn't even raised as a point in the Court of Appeal, was it?
The point in the Court of Appeal was put differently. I accept that.
Exactly.
Yeah.
So you might seize the grounds at page 1097.
Yeah, I accept that. What I can't say and don't know, frankly, but I can take instructions, is whether the position in Trinidad in terms of the suggestion of the Court of Appeal in this case of getting the judge to expand on its reasons is one which is adopted in Trinidad.
No, but I mean, it's not very satisfactory 8 years later. You're saying to the judge, oh, sorry, your judgment may be fine, but you just didn't spell out one aspect of it.
Well, with respect, the point which is made, and has been made throughout, has been that the treatment that the judge expressed of the uncompetitive environment is unsatisfactory. That's in the grounds of appeal, it's in the printed case, and it's the submission that we advance now.
Yes, but what we're trying to do is to identify the point of law.
Yes.
And obviously, you may not like the way he dealt with it on the facts, but that's not for us.
No, I understand. Well, my lords, I perfectly understand that. I perfectly understand the hurdles in the case, which are not, which is your lordships will have a keen eye to. But nonetheless, in our submission, it is important that reasons, and it's particularly, if I may say so, important in this jurisdiction because sometimes, rarely, of course, in this level, but sometimes Homer nods, and sometimes first instance judges miss a critical point. And it is on any view odd, and I don't want to overstate it, but it is odd in the extreme that something which is set out in extenso earlier on isn't dealt with expressly in the judgment. And there, as I say, there are three potential options, and actually none of them are expressed. It just seems to disappear into the ether.
Yes.
But the effect of there being less competition would be that the top line would be greater, that you'd have higher advertising revenue. Is that right?
Yes.
Yes. And yet, these figures, the figures of advertising revenue, I don't think were seriously questioned by the judge. What he did alter was the lower lines of the spreadsheet. He altered the level of profit.
That's true. There is a second point which I'm happy to come to quickly if that assists, or less quickly if I can get more traction where I am at the moment.
Well, I think we've got the first point.
It's not a very sophisticated point. But I'll complete the submission by at least making this point, which is that it's important from the point of view, in any case, that the parties are clear about how their primary submissions are addressed. And I don't express any criticism of the respondents, but when the submissions ranged over so many different areas, which they did, as you can see from the skeletons, that shouldn't deflect the judge from dealing with a central point, which actually was not in itself contested and which was subject to cross-examination. That's quite important.
Yes.
Anyway, that's the submission.
Could I just clear up something which is puzzling me?
Yes, sir.
On page electronic 1081, we've got the projected profitability advanced by the claimant's estimates, haven't we?
Yes, we do.
And the judge pretty much took that, but making a reduction for the 10% in relation to expenditure. Is that right?
Well,
Not in relation to the 160.
exactly. That's the second point.
Yeah. But we're just looking at the question of the figures at the moment,
No.
which is what you're addressing, isn't it?
Yeah, well, yes, although it has to be recognised that obviously when you're talking about the absence of a competitive environment, that's a factor which will operate over time. So it's not.
Yes, I understand. But just concentrating on year one, which is
Yeah.
what you were addressing at the moment, isn't it?
Yes,
Yes.
but just so that we're clear, obviously, if the factor of a competitive environment ought to be something that doesn't cease after year one, because in
Yeah.
fact was the position in 2006.
Just looking at year one at the moment,
Yes.
I think your argument is it's too low because the environment was a kinder environment at that time.
Yes.
Okay?
Yeah.
So the projections were prepared for the purposes of this hearing?
They were.
They were. And was it being submitted to the judge, but you should abandon those projections and take something else?
It effectively was, yes. I mean, what in fact
In
happened,
relation to that year one figure?
No. There are many elements of this case which are. What was actually done, but by the time of the trial, the 2007 figures were available. The 2007 actuals.
Yes, I got all that. But
So
was it
in
being
fact-
submitted that he should abandon these estimates?
Well, the primary submission from the appellants was they should use the actual figures, but that wasn't the course the judge took. The judge, in fact, decided to use the estimated figures. Now, I was going, in relation to the second
So
submission.
the actual figures were the figures for the later period, you mean?
That's right,
Yes.
And only for year one.
and only for year one. Absolutely, and that was the position the judge took. So
he basically took a view by rejecting the actual figures and using your projections. He was taking a point in your favour.
well, he was.
Because you can assume that your estimates were what your clients contended would have been the year one figure.
That's true.
And why should he have spent time, including in his analysis, the exact impact, the contribution which had been made to that figure by the more clement competitive environment 5 years earlier, if effectively that was taken into account in your projections of year one, which would be the natural assumption one would make?
Well,
It seems bizarre to go into the elements of a figure which is being taken from your own clients.
well, I accept that, but I also, I mean, well, I should just correct a slight incorrect answer I gave to Lady Black, which was the figure of 245 was, of course, slightly reduced because of the cost.
That's what I,
Again, 225 rather than
that's what I
245.
said, yes.
Yes, but that was the result of cross-examination,
No, I
where
understand.
it was accepted that certain costs had not been included in the spreadsheet.
So I understand that. I simply wanted to make sure I
Yeah,
had
that's all right.
the correct answer. Well, one can see, let me put it this way, the problem becomes more acute when one turns to the second complaint, because there the judge says there's a 160% increase, when in reality there isn't. And I need for that purpose to turn to the income estimate, which we've passed up to you. And
Yes.
I'm afraid the copy, again, for those of us who can see very little.
This is a point of law or just a point that he's made a fundamental mistake of fact?
Well, he's misanalyzed the figure.
That's a point of fact.
Can I just explain?
Can we get it clear? I mean, you know the difference between a point of law and a point of fact
Yeah.
as well as anyone does. Can we please at some point identify what you say as a point of law under your second point?
Well, but the submission I make is that when one looks at the figures, he's wholly misanalyzed the figures.
Are you saying that's a point of law?
Well, it is when you actually. if I could make the point, and then
Well, I
it's
think
quite
what you would say is that where a judge wholly misapprehends the proper analysis and reaches a primary finding of fact for which there is no evidential support, that is an error of law.
I would with respect accept that. I mean, I also
It's also an exception
Yeah.
from the concurrent findings.
Yeah.
well,
That was supposed to be helpful to you.
it was helpful to me, and I'm sure if I may put it this way, if I could make the point,
Yes, go ahead
then
Let's hear the point and then...
and then we can take it from there.
yeah, right. Let's hear it then.
Okay. What it comes to is this: is that I don't know whether you've had a chance to look at these figures very clearly, but on the left you can see various categories, and we have 12 months across to 2001. That's left to right, and then we get subsequent years. And you can see that income, I'm now going down the left-hand side of the page, is advertising. The direct costs, which appear to be the costs of radio program making, gross profit, and then we have two forms of expenses, which seem to be the expenses associated with selling, and then what I could call backroom costs, which are from administration downwards.
Overheads, effectively.
Perhaps, yeah. And then you'll see the total expenditure, and then at the very, well, not the very bottom, about 5 lines up, net profit. Okay? Yes. Now, if we look at the profits for 2001, they are 245,000 odd, if you can see that.
Mm-hmm.
That's, and then for 2002, it goes up to 639,000, which is 160%. That's the figure the judge is exercised by. However, if you look at the income side of things, you'll see that in 2001, the income was 2,850, roughly. In 2002, it is 3,520. So there's an increase of the income of 23.5%, which is rounded up to 24. If you then look at the cost side of the equation, you can see that the costs have increased very slightly. The total costs, which is two figures added together, the 1,105 and the 1,499, this is for 2001, come to 2,604 odd. For 2002, it's 1,172 odd plus 1,707. They're coming to 2,880. So in fact, the difference of the cost increase is 10.6%. So basically what's happened here is the income has gone up by roughly 24%, and the costs have gone up by 10.6%. So the actual reason why the costs are, the profit's 160% is because the costs figure did not rise proportionately to the revenue figure, which is hardly surprising given the nature of the industry we're talking about here. So what my point comes to is that it's the figure of 160% is the figure of 160% to deal with the profitability concern is in fact easily explicable on the figures, and it isn't actually in crude terms an increase in profitability. What it actually is an increase in revenue and a less than proportionate increase in costs.
Why isn't that an increase in profitability, given that the one is the result of deducting the other?
Well, I agree with that, but to suggest it's unexplained, it is actually explained if you look at the figures. And again, in our respectful submission, it looks as if the judges reached a conclusion without analysing the figures. It's also worth saying that the question of the proportionality of costs increasing over time was the subject of cross-examination.
Right.
And so what it comes to is simply that point, which is that the difference between the increase in profitability of 160% is explicable, in fact, by looking at revenue and costs, and it isn't, as the judge appeared to regard it, as being as remarkable as all that. In fact, it's a mathematical consequence of the fact that costs rise less fast quickly than profits. Well, that's the point.
That's it.
And unless I can add anything further on that, I'm obliged. The third point, the cost point, is very quick indeed. And really, I make the following points about that. It was recognized by everyone in the case, including the judge, that this was damages cases for equality of treatment under the Trinidad Constitution at that stage were very rare indeed. It was the second case before the High Court. The judgment referred to it as novel. And it's worth pointing out, although I needn't take you to it, that the cost order that was made and the judgment that relates to it was unreasoned, short, and it was unexplained. When the judgment was made on the 23rd of September of 2009, it's worth noting that the issues in the case covered much broader spectrum of issues than the ones that I've drawn to your Lordship's attention, and I venture to suggest took a bit longer than I have. It's worth reminding oneself is that there was an analysis of general principle, which was important in the context of a case at this early stage, a review of compensatory damages, and a question about the role and scope of vindicatory damages, which of course is the proper categorization of this type of damages. It's also worth pointing out, as your Lordships may know, that there was no domestic jurisprudence on equality legislation at this time because, as you may know from the Surratt case, which is impassive in this case, the constitutionality of the equality legislation in Trinidad, effectively the government declined to implement that. That was overruled by the board in Surratt. There was a second set of proceedings in 2009, and that still hadn't been implemented. So basically, the only material that the Trinidad courts had to work with were the two previous cases. It's also worth pointing out that senior counsel was instructed on behalf of the respondents. Indeed, 3 counsels were on both sides. And therefore, we would respectfully suggest is that given the nature of the exercise which the judge had to embark upon, the very terse way in which he said the usual order, which is the only explanation he provides. It's not an explanation, it's a result, a result which without reasons.
Well, it meant that he was not satisfied that there were reasons for departing from the usual order. In other words, having sat through the trial and having assessed whether the difficulties of the issues justified something more generous, he decided not. How can we decide that he was wrong about that?
Well,
we haven't had the advantage of sitting through the trial.
No, of course. You haven't had that advantage. But the answer that I would give to my Lord is simply is similar to the first submission, which is however brief judgments are supposed to be, they're supposed to give us a clue as to the basis upon which it was given, and that simply didn't.
Yeah.
That's the submission.
Right.
May I? Thank you.
Mr. Logan? You don't have to follow, but you may, briefly, if you wish.
Indeed, my Lord.
Yeah.
I shall be less than 5 minutes. I
Good.
just to make 2 short points. My Lord, the way the case was put in the courts below, and the principle of law, which I'd like to draw to the board's attention, is that whilst the estimates which were provided were speculative because there would have been no actual radio station to compete for this niche market, which was the Hindu community in Trinidad and Tobago, the best evidence that would have been available to the trial judge became the empirical evidence after the radio station commenced its operations, at a time when the competition had increased from 9 stations in general, with none in this particular niche area, to 39 in 2007. And that jump from 9, at a time when you would have had a virtual monopoly by a very powerful organization with a ready-made target market, namely the Hindu community, had now jumped from 9 to 39.
But am I not right that the only station that was targeting the Hindu community as a religious station was yours?
That's correct.
In 2007, as in 2001?
Yes, my lord. In 2007, by that time, there were at least 5 to 7 competitors in that niche area. But the point I'm making is that in 2007, when they commenced trading.
What, a Hindu religious radio station? Or merely catering for the Indian community?
That's correct, my lord. That's correct.
The latter?
Yes. So the short point is that the projected estimates, when you weigh that in the balance against the empirical evidence of the profit made at a time when the competition increased from 9 to 39, the actual figure recorded being higher than the projected estimates which were put forward at a time 7 years before when you were applying for a radio license, the judge ought to have had regard to the best evidence rule, which was the actual empirical trading figures, and bearing in mind that such a profit, which exceeded the projected estimates 7 years before, that was in fact exceeded 7 years later at a time when there was so much competition.
Yes.
He ought properly to have factored that into his base figure for calculating the award of damages. And that was the concentric point made by the appellant in the courts below. I'm going to demonstrate that. I quickly can take you to the notes of the submissions. There's no transcript, but my lord, if I may just take you to the notes of the submissions to show you that that was in fact the what's the notes of submissions? It is to be found in the notes of submissions at it's in volume 1, and you will see it 2 pages from the back. It's page 447 in the electronic bundle. And you will see under submissions, and these are just the judge's brief notes, but there was extensive submission on it. The Mahasabha had a monopoly of the Hindu market. Which is more credible, the projected figures or the actual figures? No competition versus intense competition, and use the same growth rates projected, and there was no evidence from the state. In a case where there was no rebuttal evidence from the state, where there was a virtual monopoly, had the license been granted when they were entitled to have it, and to move from that to a position where from 9 to 39 stations. I
think we have the point about...
I'm obliged, my lord. So we say, my lord, that the judge ought to have had regard to the best evidence in the case, and used and was obliged to factor into his analysis the actual figures that were recorded in the first year and some months henceforth post-trading, my lord.
But
my lord,
how much evidence was led about the actual trading after year 1?
Well, my lord, I think that we led what could have been led in terms of the number of months up to the point that the trial of the assessment took place.
Which was?
July
2009.
July 2009.
July?
2009.
Yeah.
Yes.
It was the 23rd of September 2009. Sorry.
Yeah, 23rd of, is that when we
it's
addressed him?
Yeah,
No, that's the judgment. When was the trial?
10th of July,
I'm
possibly.
obliged, my lady.
432 of the electronic bundle.
I'm obliged.
Right. Well, do you have another point, Mr. Ramlogan?
I'm obliged, my lord. That's, that would be it. But on the cost point, my lord, briefly, we say this. You will see that the state in its submissions accepted that, that this was in fact the first of its kind for our jurisdiction. We say that the general rule cannot be applied in a case that was by its very nature exceptional and novel and complex, which was accepted by the respondent. There should be some reason given in the judgment for saying that the general rule is being applied in a case which the judge himself and the state accepted was exceptional on the facts. We say further, having regard to the findings made and the reasons given for the award of vindicatory damages, that part of the vindication of the constitutional right which was breached surely must include in the exercise of judicial discretion a favorable exercise of that discretion in relation to the award of costs in favor of the victim of the discrimination, more so in a case like this, having regard to the strength of the findings, which included the Court of Appeal being twice misled into giving judgment on their serious misapprehension as to the facts as recorded by Lord Mance in the board's judgment on the question of liability. But we say an element of the vindication of the breach of the constitutional right ought properly to have been a relevant consideration in the exercise of judicial discretion on the question of costs. I thank you, Lord.
Thank you very much indeed. We'll rise for a few minutes to see where we go from here. We're very grateful to Mr. Clayton and Mr. Ramlogan and, of course, Mr. Richards and those who have been responsible for the preparation of the hearing. But in the circumstances, we don't need to hear from you, Mr. Rowe. Thank you very much. The board will take time to consider that judgment.